A look at the reaction Friday after the Supreme Court ruled the Constitution guarantees a right to same-sex marriage. Our next guest is a true conservative who won the case that made George W. Bush president and then served him as Solicitor General. Which is why it's so interesting Ted Olson has been one of the leading advocates over the last decade for same-sex marriage. Mr. Olson joins us now, and welcome back, sir, to Fox News Sunday.
Thank you, Chris.
So let me ask you, what means more to you personally, your victory in Bush v. Gore or this ruling which set forth a constitutional right to same-sex marriage?
Well, you can't equate the two, but to see those people expressing that joy and that gratitude and those tears of happiness that they will be treated equally under the Constitution with respect to the most important relationship in life, the opportunity to get married to the person they love, touches me deeply, and it's very, very important in my heart.
There are two major criticisms of the ruling, I think. Maybe there are more, but two I want to focus on. First, that the court, in effect, invented a constitutional right, made it up just like they did on the right to abortion in Roe v. Wade. Here's Governor and Republican presidential candidate Bobby Jindal.
It's clear to me the Supreme Court is no longer acting as a judicial body. It's now become a public polling body. You've now got a Supreme Court that is out of control, that is making up laws as it goes.
How do you respond to Governor Jindal?
14 times the Supreme Court of the United States held that marriage is a fundamental right, including the right to interracial marriage in 1967. They didn't call it the right to interracial marriage. They called it the right to marriage. They described it as a right to liberty, privacy, association, being a part of this country, being a part of the relationship that matters most to most people in this country, and to be a part of our community. So it's a right to marriage. This is not something that the Supreme Court made up. It's the right to decide who you would get to be married, which the Supreme Court repeatedly said is a fundamental right. So there's nothing new about this decision. It takes it one step further because it hadn't been recognized before, but it's the right of two individuals to marry to the person that they're most devoted to.
The second criticism is that the political process was working, that states were changing laws, public opinion was shifting, and that the court, in effect, short-circuited that process. Here is a quote from the dissent of Justice Scalia. He called the ruling a threat to American democracy. Is Scalia wrong?
Yes, with respect to Justice Scalia, who I do have great respect for, he is wrong. When we talk about civil rights, we don't wait for a plebiscite. We don't wait to put civil rights to a vote. The Supreme Court didn't put separate but equal schools to a vote. The Supreme Court didn't put the right to marry someone of a different race to a vote. We don't wait. And Justice Kennedy, in the majority opinion, talks about that. What is happening to the children? Well, the Supreme Court would wait if it was to wait another few years. At the same time the Supreme Court had decided the interracial marriage case, there were still 16 states that made it a crime to marry someone of a different race. The Supreme Court did not wait then, and it was right not to wait now.
As big as this ruling is, there are some issues that it didn't apparently settle, and I'd like to ask you about that. One of them is extending anti-discrimination laws, state and federal, to gays. Where does that stand after this ruling?
Well, it's going to depend upon additional federal legislation if the federal government decides to do that, or state or municipal legislation. There are state laws and there are municipal laws and there are some federal laws prohibiting discrimination on the basis of sexual orientation, but they don't cover everything. They don't cover necessarily housing or commercial transactions and things of that nature. So I think the LGBT community will be pressing for laws that entitle gays and lesbians to the same respect and anti-discrimination protections that other people of other religions have, or people of other races or nationalities.
Second, there's the question, and it became hot this spring, of religious freedom. Can the proverbial baker or photographer who's selling his services openly, can he refuse to participate in a same-sex marriage because he or she believes that it violates their religious freedom, or is that now illegal under this rule?
It's not illegal under this ruling. There may be laws, statutes that cover it, but a bakery, if you walk into a bakery and on the street and want to buy a pie or a donut or something like that, the bakery under federal law can't discriminate against you on the basis of your race or your religion. So if there are laws that cover that kind of discrimination, that might be illegal. It's different than someone being asked to participate in a wedding, to perform a wedding, to sing at a wedding, to participate and be a wedding planner or something like that. People have the right to refuse personal services with respect to things like that on a religious basis. I think some of that dispute is overblown, and the courts have been dealing with that kind of an issue for many, many years with respect to religious rights and racial discrimination and discrimination on the basis of gender for a long time.
Chief Justice Roberts wrote in his decision that if there is a constitutional right for two people of the same sex to marry, then what about three people marrying or other varieties of arrangements? This was brought up by the Chief Justice.
Yes, and I think that with respect to the Chief Justice, I think the Chief Justice is wrong. He bought into a red herring. There are reasons why states and the federal government might prohibit relationships, marriage relationships between multiple persons, the rights of children, what happens when the marriage breaks up. The test is always, what does the state have in its interest to prohibit the conduct that's being considered? The states that were involved in the case that was decided Friday could not come up with any good reasons why to prohibit persons to marry the person of the same sex, the person that they love. They came up with, well, it's against traditional marriage. Well, that's like saying separate schools were a tradition, or restrictions on marriage between people of different backgrounds was a tradition. You can't explain something by saying it's the way we've always done it.
You are one of the leading Supreme Court experts and watchers, so I'm going to take advantage because we're up at the near the end of this session to switch subjects on you a little bit. What did you think of the court's other big ruling this week? I'm sure you read about it. I know you weren't involved in it. That the Obamacare law, that what it set forth specifically in the law when it said exchanges established by the states, was the key is not those words, but what was intended. What did you think of that rule?
Well, I think that was a mistake, and I think that it's kind of interesting to look at Chief Justice Roberts' opinion in that case versus his dissent in the marriage case, because they almost could have been written by two different people. In that case, he was taking a law and trying to discern what the intent of the law was, notwithstanding what the words were. The words were exchanges established by the state. That was the trigger for subsidies. And the court held that exchanges established by the state, or where the state refused to establish an exchange, and it was established by the Secretary of Health and Human Services. So the words were changed because of what the court perceived the intent of Congress was, but you can only discern the intent of Congress by the words that Congress used, not by the imaginations of judges with respect to what 535 people meant when they voted for or voted against a law.
Well, the argument is that there wasn't a conflict there because Chief Justice Roberts supposedly was deferring to the legislature, and that in deferring, in this case, and some could say it's an odd form of deferral, but that he was looking not just at the words, but also at legislative intent, and that is something the courts traditionally do, and that he was, in a sense, deferring in this case, in the same-sex marriage case, saying, hey, if the legislatures want to decide this, they can decide it, but it isn't for 9 robed justices to decide it. In both cases, he would argue it was restraint.
Well, in the first instance, in the Obamacare, which Justice Scalia said should be called SCOTUS care, right, Supreme Court care, there was legislation. It had explicit language in it, and the court went beyond the language and said that language didn't mean what the language did mean on its face, and discerned what the intent of the legislature was. The second case involves the Constitution of the United States. In the first instance, we have a legislature that can change the law, can fix the law, can solve whatever problems the law might present. In the second case, it's a constitution.
But,
and we have rights.
I mean, excuse me, sir, but some people would say you're also sort of in contradiction here, because the argument is, well, the political process, defer to the legislatures. They can decide whether or not same-sex marriage is legal.
Well, but you cannot defer to legislatures or to plebiscites when you're talking about the meaning of the Equal Protection Clause or the Due Process Clause. The reason we have a Constitution is to restrict and correct the rights that are decided upon by legislatures. We have a Constitution that protecting the right to religion, the right to free speech, which Fox News has, because if the legislature passes a law restricting your right, you turn to the courts. That's the difference between a constitutional decision and a legislative decision. Whatever the courts decided on the Obamacare case, the legislature could come back tomorrow and fix it.
Okay. Final question. We've got less than a minute left. As the court ends its term on Tuesday, if you look at its rulings, and I'm sure there are people who object to this, it seems to be one of the most liberal sessions, in fact, since the Warren Court in the 60s. More than 50% of the rulings have tilted left. Question, which a lot of people are asking, is the Roberts Court moving left? Well,
that's the problem with snapshots. Last year, the people were writing that it was a pro-business court. And now this decision comes along, these cases come along, and people said, well, it's a liberal court. You have to look at the individual decisions. Yes, many of the decisions this term came out the way that the liberal members of the court preferred that they come out. Next term, it might be completely different. Depends upon the case.
But you don't see this turning into the Warren Court?
I think it's mischaracterizing and oversimplifying things to call it a Warren Court or a Roberts Court. Might be a Justice Kennedy Court, the way things work this term. But I sort of won't go there.
Mr. Olson, thank you. Thanks for coming in. It's always good to talk with you, sir.
Thank you. I really appreciate it.